We're here today first for some motions in Zachary Rye Adams versus the State of Tennessee, docket number 17 CR 10, post-conviction. But I've had the witnesses that are subpoenaed to testify come in the room. Are all the witnesses that are subpoenaed to testify present? Raise your hand if you're a witness, please, so I can see you. All right, to all these witnesses, you're instructed to follow these rules carefully to protect the fairness and integrity of this trial, or this hearing. Unless otherwise instructed by the court, you're not allowed to sit in the courtroom or receive any information about the case before you've testified. Until the court releases you, you must not do the following. Do not discuss the case. Do not speak about this case with anyone, including other witnesses, family members, friends, or attorneys. Do not post or share anything about this case on social media or any online platform. Do not communicate about this case by phone, text, email, or messaging apps. Do not read or watch news about the case. You're not allowed to listen to any news coverage that might be published throughout the day or throughout the weeks that this proceeding is taking place. This includes all radio, newspaper, websites, podcasts, blogs, and all social media platforms. Do not research the case or investigate it for any information related to this case, including the parties, attorneys, witnesses, or legal issues involved in it. Do not use the internet or any other source to find out about the case. If anyone attempts to talk to you about the case, or if you unintentionally see or hear information about it, immediately inform a member of the court staff. Failure to follow these rules and instructions may result in contempt of court, and that can carry legal penalties. These rules apply from now until you are officially released after your testimony. All right, if there are any witnesses now that's not allowed to be in here, which is going to be one designee. Who's the state designating?
Special Agent Kathy.
Special Agent Ferguson can remain in the courtroom. Other witnesses, I'll ask you to step out and follow the rules that I just admonished you about.
One of the issues is Dr. Spearo, there's a motion.
All right, the rest of you can go ahead and make your way out. Relative to Dr. Spearo, whenever we get to that motion, I'll ask her to come back in. Right now, I'm going to ask her to step outside. No more witnesses, correct? Either side, all right. All right, ladies and gentlemen that remain, I want to remind everyone that this is a court of law. Certain rules must be strictly followed to preserve the integrity of the proceedings. You are instructed not to speak to, approach, or attempt to communicate in any way with any of the witnesses, whether in the courtroom, in the hallways, or elsewhere. This includes direct conversation, gestures, or even comments made within earshot. Any such contact, even if well-meaning, may be interpreted as an attempt to influence the testimony or the outcome of this hearing. It could result in serious consequences, also including being held in contempt of court. Your cooperation is essential to ensuring a fair and impartial hearing for all the parties involved. Thank you for understanding and for your compliance with this. All right, counsel, we do have some preliminary matters to take up before we begin the hearing. And I think maybe let's hear about the motion to amend the petition, which was filed just a few days, 10 days or so ago.
Yes, Your Honor. This motion is based upon the production of the video in question. This was argued in January of 2025 regarding the claim under paragraph 35 of the second amended petition that at the time petitioner's counsel was unaware that the video labeled BP was in fact the ATM video. After January, and it's put in the motion that was set in March, I requested informally for the state just to send me what was on General Boyano's screenshot at the January hearing. Did not receive it, filed a motion to compel, and then General Boyano walked through in his pleading response, then filed the night before, where this BP video was that's actually the ATM video. Once I received that, petitioner's counsel and others have gotten to work to prove the impact of that video. And the impact of the video is illustrated in this amended pleading. What it amounts to, Your Honor, is we will prove by clear and convincing evidence Zach Adams was actually innocent of these charges. That's the effect that the video's final production to us has shown. It also showed other problems inherent in the prosecution of this case that we've properly laid out in the petition that's amended. It is necessary to prove to the court, and this evidence came to us in a way as it did that showed this amendment is necessary. I think it's helpful to the court to lay out the facts and how it's relevant. Although, to be fair, paragraph 35 acknowledged this was going to be an issue. And I have followed back up, and that's the purpose of this amended pleading.
Mr. Boyano, you responding to the state?
Yes, Your Honor. So, Your Honor, our position is that this wasn't produced to Mr. Bates or Petitioner Adams. He had, or Jennifer Thompson, trial counsel, had this going back to, I believe, 2015, when it was originally produced in discovery on a hard drive. That hard drive was handed over to post-conviction counsel, we believe, sometime in the fall of 2023. We, being...
After this post-conviction petition was filed?
Yes. That the hard drive that Jennifer Thompson had, that TBI gave her as part of the original discovery, was handed over to post-conviction counsel as part of the whole file of hers. TBI went into Mr. Bates' office in January to copy all materials, which included that hard drive that Jennifer Thompson gave to Mr. Bates. On that hard drive, we were able to confirm that this ATM video has been there since it was originally produced by the state back in 2015. So this is not something that is new. Mr. Adams, through trial counsel and post-conviction counsel, have had it. We certainly specifically identified it in the motion I filed as to where it was on the hard drive. That we are not, however, we are not asking for a continuance. That the rules are pretty flexible with the court allowing a petition to add claims as the proof develops under Rule 28. So our position is that it is certainly untimely that this was filed when it was, but we are here to go forward. And we would simply say for all claims that we deny and would demand strict proof thereof in
Which
the
you
amendment.
included in your response?
Yes. The IR that was originally referencing this ATM video has the video listed as BP/ATM. So it's a little more information than what Mr. Bates provided in that IR. Thank you.
All right. Thank you, Mr. Boyano. All right, Mr. Bates, I'm going to grant your motion to amend. Rule 28, Supreme Court Rule 28 clearly allows for liberal amendments, and we'll draft an order setting forth that. I do want to, I may not be going in the order that you all recognize, but I do want to put on the record that one of Mr. Adams' attorneys at trial, Mr. Gonzalez? Okay. Will be allowed to be deposed at a later date. All right, Mr. Bates, you want to proceed with your motion for sanctions?
Yes, Your Honor, and I anticipate the court possibly reserving ruling on this until it hears more evidence in this case. And I'll keep it brief. The timeline of this video that General Boiano said is correct. The timeline is IR 1845 generated by Agent Lewis, who is here, shows a DVD labeled BP/Community South Bank ATM. At some point, it was created on a hard drive provided to defense counsel, and it was labeled BP. And it never stopped being labeled BP. Then the plot thickens when Agent Joe Walker, and let me say now, the state filed 600 potential witnesses. The lead case agent, Joe Walker, was never identified on their potential witness list. Joe Walker issues a judicial subpoena to Shane Austin's bank and says, Shane, Zach, Dylan say they were all together that day. We need to find their bank transactions to confirm it. The bank subpoena comes back, and it shows an ATM withdrawal. Joe Walker then, and this is, it'll come into evidence, but it's IR 2743, date, activity date 9/30/2014, report date 10/6/2014. The transactions for April 13, 2011 were as follows. $120 from the ATM at Community South Bank. $22.02 from Shell Service Station in Holiday, $10 from MAPCO 2012 in Parsons, $9.84 Shell Service Station in Parsons, and $6.78 from Sonic Drive in Parsons. A check of video recordings from that date is to be done when a player is obtained for the MAPCO and a BP video from 641. The other places were not covered by our videos. Now, this is in 2014. The record and evidence is going to show that defense counsel tried everything they could do to get this video. They issued a subpoena to the bank. It came back and said, we have no, after diligent search, we have no such video. Then Jennifer Thompson repeatedly in the record filed motions. First, sent emails to General, I believe, Hagerman, and continually referenced BP video. The state's response always, and what Thompson was saying is, I cannot open this on the format. She's going to testify under oath. She could not open it on the format she had. It's without dispute, I'm able to open it on the format I had, without dispute. The court's going to have to weigh the credibility as to whether Ms. Thompson's credible when she said that she referenced being unable to open it repeatedly. It was the basis of her continuance request. I'm unable to open this. Trial happens. Mr. Adams files his pro se initial petition, references ineffective assistance of counsel, saying, hey, there was this, why didn't you get the ATM recordings? Then work was done with petitioner's counsel through also petitioner's agent, Dr. Spearo, to identify the security officer in Alabama who had the original ATM machine, trying to find it. Now I want to pause here and say what the state might say. Well, why didn't you just open V8 and check? Because it was labeled BP. Foolish us. We trusted the state that it was a BP video. Foolish us. At that point, Mr. Mayfield said, I've got a video, a DVD labeled 41311. If you want it, I'll need a subpoena. This was, and I believe I've pled this, this was when I came to an agreement, try to stick by my word, let Jennifer, then General Nichols know I'd like to issue this subpoena. It was procedurally unclear where we were, if it was a writ of error quorum nobis or PCR. I think we're under the writ of error quorum nobis at the time, and therefore the rules of civil procedure would apply. She said no problem. Unbeknownst to me, the state issued an administrative subpoena for the very same DVD. I assume we both got the DVD back with bated breath, and we were all disappointed because it was a very limited scope of time, which tracks with Agent Dykas's work prior, which was essentially just trying to find vehicles with the victim in it. It was it was early morning. Mr. Mayfield had said, though, I'm still trying to find the machine. If I find the machine, I'll let you know. Several days later, Agent Ferguson issued an administrative subpoena stating that they were investigating this case. And never told me. Never told Dylan Adams. And the state's only position, I assume, based on their pleadings, is it's not exculpatory. It's not exculpatory that a video of the defendants at an ATM transaction confirmed by the state's own judicial subpoena that shows these individuals in the vehicle impounded by the state of Tennessee. The Silverado was impounded by the state. Somehow is not exculpatory. The state has an obligation under the statute, under the post-conviction, when you receive evidence that's exculpatory, you have to disclose it. I waited. Surely I'm going to get a phone call. Surely I'm going to get an email. the night before, or 2 nights before our hearing in May. I'm sorry, in June. I had sent my assistant to see Mr. Adams in prison. And at the time, I thought it was just a mere coincidence. But General Nichols reached out to me and said, if you're going to move to continue, let me know so we don't travel down there for the hearing in June. And I thought, well, did somebody tell y'all that I was meeting with Zach? I've since learned I one time changed assistants going to see Zach, and I got a phone call that morning from Ms. Hurd confirming that one of my assistants was actually approved. So, of course, anytime I'm trying to see Mr. Adams, the state of Tennessee is put on notice. At that conversation, I brought up to General Nichols this ATM recorder. The state never provided the administrative subpoena. In January, Your Honor, you said words to the effect of, this case, it seems like that subpoena needs to be supplied. I continue to think it was some judicial subpoena. The court ordered it on April 3rd for the state to provide the subpoena. I still didn't get it. Then in April, General Boiano said, hey, if you're going to give us discovery, we need it immediately, otherwise I'll file a motion in limine. And I sent him a message that night that said, can y'all provide me the subpoena? And that's when I got it. And what it shows, Your Honor, is under the guise of investigating a case, and I've cited that we're not in it, this is not the investigative phase. The state went and obtained exculpatory or potentially exculpatory evidence outside of Mr. Adams's knowledge. With full awareness, we were trying to get this video. And I just want to comment, in the state's pleading so far, they're saying, Judge, all that shows is just a truck. We're not worried about it being exculpatory. And yet they send Ms. Ferguson to Alabama to get it. So, Your Honor, I'm asking for sanctions. I assume the court's going to want to hear proof. Throughout the proceedings, and you're going to hear, there's no other way to say it, inappropriate conduct by the state of Tennessee. This is just the latest. And I know Agent Ferguson was just doing as she was told. The rules, the statute says when the prosecutor identifies this exculpatory evidence, you disclose it. They weren't ever going to disclose it until I brought it up. And based on this, Your Honor, I'm asking for court to consider throughout the sanction request. If the court wants to now, it can, but these are serious matters.
The proof that you would put on for this is going to be intertwined in the regular hearing. Is that correct?
Completely, Your Honor.
Thank you, Mr. Bates. Mr. Boiano?
Judge, as I stated in my the previous response, that this hard drive containing the ATM video was turned over to Jennifer Thompson by the state on June 15th of 2015. It is disingenuous at best and misleading at worst to call this ATM video exculpatory. It is a ATM video taken at on April 13th of 2011 at 11:12 a.m. It shows a truck. Has Your Honor seen the photo? Or
Been shown anything
okay.
on this.
I'm just going to show this screen. May I approach?
You may. You don't want to approach him?
That's still the ATM video at issue that,
This will be entered into evidence during the hearing,
yes.
and the video played.
Not by us, that I anticipate by.
Attached to the state's pleading, Your Honor. We'll get the court.
Judge, it's our position that this video image is a blurry video. It shows a truck. There's no one that can be identified. It was neither the state nor the defense utilized this video at trial. The reason why, and I believe that further testimony may be required from Agent Ferguson to talk about exactly how this played out, but the state intervened to take the ATM device. Spearo was involved in trying to obtain the device. After Attorney Bates told us that he had disengaged with her because of having a disagreement about the ethics of certain behavior that she was doing.
Object. They know that's not true. It's the issue. She could meet with them while she was my age. That was the issue. I opened that. That is what uncoupled us. So Dr. Spearo, from that point forward, was an agent of both Zach and Dylan. That was the issue.
All right. I'm only hearing argument on this particular motion. There's not any proof been presented to object to, so you may proceed, Mr. Boyano, but I
We also had issues with how Mr. on the 22nd, on 22nd, 2023, and videoed Jason Autry, that the circumstances around that caused the state concern, caused the federal government concern. We also were concerned about how Dr. Spearo approached witnesses such as Janet Britt, and Janet Britt executed affidavit on April 11th of 2024, saying that Dr. Spearo visited her home and told her that her husband was going to be charged with the murder of Holly Bobo, and that she would be charged as an accomplice. All these things we knew about when Agent Ferguson learned that Dr. Spearo, who no longer worked for Mr. Bates, was involved trying to get a hold of the physical ATM device. We issued the administrative subpoena to get a hold of the device. We secured it. We pulled the data from that, and we provided it to Mr. Bates, that we felt that we had a responsibility to take that evidence and make sure that both parties had equal access to it. And that is the simple truth of it, that we are deeply suspicious of Dr. Spearo and what she's done throughout this case. And it was, our obtaining this device was simply to make sure that both parties had equal access to that data and to see what was on. Nothing more.
all right.
And I believe that this could be more about this.
I'll take advisement and give you a ruling on whether or not Mr. Adams is entitled to any sanctions and what they might be after hearing proof in the hearing.
Next, Your Honor, this is now Dr. I think it might be a good time to hear Dr. Spearo's the motion to quash, or alternatively, the initial motion was to release her from the witness list and sequestration. It's since then it's been a subpoena. I would ask Dr. Spearo be allowed to come in for this.
All right, we'll allow Dr. Spearo to come in for this motion. Chief, if you want to let Dr. Spearco come in the courtroom. All right, go ahead, Mr. Bates.
Yes, Your Honor. This is the state's third effort to issue a subpoena to Dr. Spearco, and I want to address first the subpoena ducus tecum part, and secondly, the subpoena to testify as a witness.
All right.
The state said in January, before the court ruled that the subpoena ducus tecum was not right, they were not calling Dr. Spearco as a witness. I said I'm not calling Dr. Spearco as a witness. I stand by that. I'm not calling her as a witness. The state issued their 600 witnesses, didn't include Dr. Spearco. Court asked for a witness list, included Dr. Spearco. I think the record will show in between that time, Mr. Dana McClendon requested under Rule 30 media privileges during this proceeding. Dr. Spearco was listed on the state's witness list without a subpoena. The initial motion was, and I stand by this, the state's real intent is to sequester Dr. Spearco during these proceedings. As I said, she can provide no credible evidence as to what took place from 2011 to the end of the motion for new trial. She's not a custodian of any record sought to be introduced through her. The state is not asking her to be an expert. Now, so the initial motion was she's not going to be a witness. We all know that. We all know the purpose of this is to sequester her. Now that the state has issued a subpoena, it's further complicated. First, the court ruled that compliance is not required until this court rules. The subpoena compelled her to appear with various things that mimicked exactly, I believe, the subpoena ducus tecum that the court said compliance is not necessary. So the first thing I think the court has to do is rule on what was argued in March as it relates to the subpoena ducus tecum. All of the arguments regarding Rule 16 that she's an agent apply. Rule 16 does not mandate disclosure of the defense agents. Rule 17 doesn't apply either in Rule 28 post-conviction proceedings. And I thought about it, it's like, why would that be? Well, if you think about it, the statute requires counsel to do a full, meaningful investigation in between the appointment order and filing an amended post-conviction petition. It makes sense that you want to let counsel have a full reign of interviews, ask as many off-the-wall questions, prod, poke, pierce your way through without having to disclose that to the state. In other words, you want a full investigation, which is what Dr. Spearo, prior to the Dillon issue, was helping me with. And I've heard this before that, well, she went to Memphis as a neuropsychologist. Of course she was in Memphis as a neuropsychologist. I mean, I understand these are serious allegations in these petitions I've filed. I wanted Dr. Spearo as an expert to provide a common sense check and a professional experience check on this. So of course she was as a neuropsychologist. Same with Zach. In all fairness to the court, she went to see Zach, and one of my questions was, is he telling the truth? Before I spend several thousand hours on this, I'd like to know from an expert basis what I'm dealing with. Dr. Spearo has performed forensic evaluations of mine in custody cases where she says, I don't believe your client. That's part of her expertise to the court. So much of the work they're attempting to obtain is protected under Rule 16. The state filed a motion on June 3rd, 2015, where General Nichols shows a profound awareness where she discusses it. 16A2 specifically precludes the disclosure and inspection of reports, memoranda, or other internal state documents made by the District Attorney General or other state agents or law enforcement officers in connection with investigating or prosecuting the case. Nor does Rule 16A2 authorize discovery of statements made by state witnesses or prospective state witnesses. And the same, it's reciprocal. So, because even though Dr. Spearo stopped working at my request, she's never stopped working at Zach Adams' request. So all of these documents is protected under Rule 16. She is here to argue. She's also become a member with a podcast. She can speak to that. As it relates, though, to her testimony, the state is going to ask you to trust them. Just trust us. And their standard is, we might call her. I don't know yet. We might. Which she will then be sequestered. If she is called to testify by the state, nothing would please me more. Because on cross-examination, I will seek to certify her as an expert. And you will hear her expert qualifications, and she will discuss with you the ways in which, from a neuropsychological perspective, people lie. When they're told they're going to be killed, when they're told they're going to be put to death, when they're told their kids are going to be taken from them by the state, when they're told, it helped me, it helped this case, if we can get this detail lined up. Because of that, Your Honor, because if they're going to call her, I'm asking her to be qualified as an expert. I'm relying on Rule 615 that's 6.3 that says she will be an expert if called by the state, and therefore her expertise will need to watch the witnesses in court and help the court understand from a neuropsychological perspective what's going on. Additionally, there's another reason for her to not be sequestered.
Your position here is that any criminal defendant can hire a neuropsychologist and retain them as an expert witness in any criminal trial, and then that expert witness can sit and watch all the testimony from the stand, then get up and testify as to who lied and who told the truth?
I'm not saying in any case. Absolutely not. Absolutely not.
Explain what you just said to me.
All right. The state had three main witnesses: Jason Autry, Victor Dinsmore, Rebecca Earp. Jason Autry's statements throughout the entire trial, the entire investigation, was he's 100% innocent. Mr. Scholl said on the outside the courtroom in Decaturville, our client didn't kidnap anyone, didn't rape anyone, didn't murder anyone. He's prosecuted under the death penalty. He fabricates a story to get out of the death penalty. When he pleads out, the state says his testimony answered many factual questions left open by our investigation. Rebecca Earp said multiple times evidence that did not benefit the state. It wasn't until Valerie Trout says to her, I want to know once and for all what it is, and whatever you say, we're going to send up to the TBI, and there might be new charges coming against you. But the best of all is the Victor Dinsmore, and we'll get into this soon when the proof opens, where he went from the corroboration regarding this white Nissan truck that had to be in the garage, because Jason Autry said it. Agent Booth asked Dinsmore, was the truck in your garage? No, it didn't happen. No, sorry, wasn't there. And then in a span of 10 minutes, you'll see, the expert will see how flimsy a vulnerable person's memory can be revealed to believe anything and say anything. So that is what the meat of this case that Dr. Spearo, if she's allowed to testify by the state calling her, can help from a neuropsychological perspective. Now, I'm summarizing. Dr. Spearo, if she's called by the state, can expound on that. I think in the parlance of criminal work, it's called a false confession expert, which Ms. Thompson and Mr. Simmons attempted to try to investigate. And the proof will show kind of why that fell apart. The other part of Dr. Spearo, she can discuss with you, for instance, this completely false confession by Dylan Adams and other evidence that's in her wheelhouse if she's called by the state. The second part of her work is she has done enormous work on this case. First under my umbrella, and second under Mr. Adams' umbrella. I cannot I cannot begin to describe the depths of this discovery. This is not an easy case for anyone. Any defense attorney would have to choose between making a living and handling this case. Initially, I tried to be as efficient as possible and asked Dr. Spearo to help as she would on other cases that I've had. I've had her on a criminal case involving a mens rea issue. I've had her on multiple custody cases. Her work is very valuable. There are things, frankly, she probably knows better than I do, possibly better than anyone else in the courtroom. I anticipate at breaks discussing with her. This witness said this. What about this IR? Well, various things along the way. Because she's Zach's agent, I believe that is fundamentally permissible. The state is unable to tell you right now what she's going to testify about. Their pleading says it may trigger. So my request is that she be not sequestered. If we're going to say she's going to be a potential witness, she won't be sequestered. The third request along this line is that I think absolves any concern the state may have. And I'm requesting under the court's authority to issue a protective order to any potential witness in this case to not make any public statement whatsoever until this court rules, not until they testify, but until this court rules. And the reason is several-fold. First, it absolves any concern whatsoever that Dr. Spearo is going to get the benefit of not being sequestered so she can participate in a podcast that she's previously participated in. She'll be barred by that. If she does, Chief Fielder can provide her accommodations under contempt powers of this court. Second, and this is why it should apply to all witnesses, I've heard that there are media outlets covering this case and that there is potential for following the news each day. The last thing we'd want in this bench trial is a witness to say something, somebody finds it out, and then we have to recall this witness because they're providing inconsistent statements. And so, for that reason, Your Honor, it seems that the best way to approach it is to say, okay, if you're a witness in this case, no public comments on this case until the court's bench ruling. Dr. Spearo, the documents should be quashed under Rule 16. She can argue the reporter issue. Her testimony, to the extent she's under subpoena, she will remain under subpoena. She can stay in the courtroom under Rule 615. 3, if she's called to the stand by the state in defense, I will rely upon Rule 702, 703 to attempt to make her a witness, an expert witness, and in doing so, under Rule 705 will be facts that come in this proceeding that if she's sequestered, I've lost the ability to do. To address any publicity concerns the state has, and I think last time they said this was a publicity stunt. Believe me, there are tons of easier ways to get publicity than this case. A blanket order that says any witness may not discuss any matter observed during this trial publicly until the bench ruling. Absolves all concerned there. Thank you.
Thank you, Mr. Bates.
First of all, I appreciate Mr. Bates explaining to the court what our position is and explaining to the court what the three key witnesses in this trial were. There were no key witnesses in a trial that included 60-plus witnesses, hundreds of pieces of evidence, day in and day out of a jury listening to every bit presented to them by both the state and the defense. The three names that Mr. Bates cited to the court, yes, they testified, but they were not key witnesses in any way, shape, or form. Everyone who testified was key to this case. And what Mr. Bates is leaving out of his rendition of what happened at trial were and I'm not even sure I can count, 10, maybe more people who took that stand under oath and told the jury what the defendant said, what they heard him say about the kidnapping, rape, and murder of Holly Bobo. Katie Spearo inserted herself by Mr. Bates into this case back in January, I believe, when an affidavit or her curriculum vitae was filed with the court, a declaration by Dr. Katie Spearo. I'm a neuropsychologist. I've been asked by Mr. Bates to come in and look at this voluminous file and help the petitioner with false confessions. Here to help. Great. Well, then the next thing we hear is that Mr. Bates has growing concerns about Ms. Spearo and about the way she's going about her job. So he told the state of Tennessee, and told the court, I'm severing ties with her. Done. Had to find a new way to stay engaged in this case. Next thing we know, she is, and I get lost in the order because the horse that she's riding changes depending on who's winning at the time, who's running the fastest. I think the next way she shows up in this case was, oh yeah, you can't subpoena me because I'm an investigative journalist. I'm covered as an investigative journalist because I have a podcast. The state of Tennessee could not care less about what is said about this case outside the walls of this historic, beautiful courtroom. What the state has a responsibility to do is, first of all, protect the conviction from a jury of his peers of this convicted murderer, rapist, and kidnapper, and to bring to the court who is the distiller of truth, to bring to the court everything that is relevant for the decision that this court must make on this post-conviction petition. Ms. Spearo has interviewed Jason Autry. They had a little sit down in the federal prison holding cell. She snuck her recording device in there, interviewed Mr. Autry,
Your Honor,
sends it to ABC 2020.
I need to object. The recording was pre-approved by the facility.
Sorry, my bad. I get confused with the different attempts of deceit and trickery that have gone on by her. I'm not accusing Mr. Bates of any of it. She sends it to 2020, this conversation with Jason Autry. The state does not know if the court is going to allow that to be played. We filed a motion in limine that it is absolutely irrelevant, and there's no way it can come before this judge in the matters before the court today on this post-conviction, but the court has not ruled on that. And if that video is played for your honor, if that video becomes part of this record, it is vital that the state of Tennessee see her file. Because the state of Tennessee, as we have filed in our responses on this issue, knows that Jason Autry was doped up when he sat down for that little conversation with Katie Spearo. And we also know it came from revenge on his part. He told his mother, excuse my language, Your Honor, they're trying to fuck me in federal court, I'm going to fuck them in state court. That was the background of that video. The state has a right to know what that complete video contains because it's clearly edited. It's clearly edited, and we have a right to see it all. I forgive me, but my brain is not large enough to follow Mr. Bates' I don't know, proposal of us calling Katie Spearo to the stand, him declaring her an expert, but be that as it may, I would remind the court that originally, again, she came on the scene as an expert, as someone who the defense was going to call to the stand to testify. And in those situations, when that happens, we're entitled to see the expert's file, everything. They're ordered to bring it to the court. Bring your whole file to the court so that the state can see what you used to reach your conclusions, and so we can show it to our experts. Now she's before the court, I believe, again, as you can't subpoena me, I'm an investigative journalist. Oh, wait, no, I'm sorry. I think the latest was, now I'm an investigator. Now I'm an investigator for Zach, and now we've thrown into the post-conviction hearing for Zach Adams. Oh, yeah, by the way, Dylan Adams. I'm representing Dylan Adams, too. She has made herself an integral part of this case, Your Honor, and despite the vast differences between her professionalism and the professionalism of the TBI agents, she's no different from any of them. They're all under subpoena. They've all been issued subpoena ducis tecum. They're all here to testify, to tell the court what they did. But it is a frightening precedent for this court to set that someone can show up on the scene wearing a hat of a professional expert. And then when that's not going the way we want it to go, when we're not really getting the information we thought was going to be helpful to us, oh, wait a minute, I know what I'll do. I know what we can do. I can be an investigative journalist. Then nobody can touch me. And oh, wait, if that doesn't fly, I can just say I'm an investigator. I'm an agent of the petitioner. Ms. Etchu and Mr. Bates are Mr. Adams' agents. That is who the law allows to speak on his behalf. But to open the door to anybody and everybody who might have thoughts and opinions on a matter is not what our criminal justice system, or our jurisprudence system for that matter, was based upon. The state of Tennessee has great faith that Your Honor can test and judge the credibility of every witness that takes the stand.
All right, Mr. Bates, if I were to decide the Autry video is admissible, would Dr. Spearo not be required to testify to?
She would not. She took somebody with her into the facility.
So you would use someone else to authenticate the video?
Correct.
Okay. Conversely,
It's still hearsay, Your
we haven't got. I'm not ruling on that.
I'm sorry.
I said that was a hypothetical to
Okay.
Mr. Bates. Conversely, though, if I rule that video inadmissible, is the sequestration of Dr. Spearo necessary?
Yes, because we still don't know where this hearing is going. I mean, again, she has inserted herself into so many aspects. Mr. Bates said it himself. That's his whole argument to Your Honor as to why you should let her sit in the courtroom to begin with, because she knows so much. She has so much information. We don't know where this hearing is headed. And every time Mr. Bates speaks, the state gets more and more confused as to where this is headed and what the issues are. And we have a right to question the witnesses and to know their biases, to know the work that they've done, and to bring that to Your Honor, to break that down through cross-examination so that Your Honor has the full picture. But that's not the only area in which she asserted herself. And I should have started with all of this, led with all of this. We're not conceding that Mr. Bates even has standing to make these motions on behalf of Ms. Spearco. The motion to preclude her from the subpoena. She had a lawyer. But no, we are not conceding that even on the Jason Autry matter that that's the only thing, simply because of all of the other areas in which she has inserted herself.
All right, I'll give you an opportunity to respond to that, Mr. Bates.
I want to, Rule 16 regarding the defense. Except as to scientific or medical reports, this subdivision does not authorize the discovery or inspection of reports, memoranda, or other internal defense documents made by the defendant or the defendant's attorneys, number 2, or agents in connection with the investigation or defense of the case. It doesn't say, it had the ability to say just attorney. It doesn't say that. Here's the analogy. In a case, let's say insanity, oftentimes the court will possibly appoint a 706 expert on the issue of insanity to be the court's expert. Oftentimes, the defense will then hire a second expert to do nothing but help the defense team interpret and extrapolate helpful information from the court's expert. What the state's position is, this expert, who's just here to help the defense, can be called to testify and bring their entire file because they have relevant information. Well, of course they have relevant information. That's why they're an agent of the defendant.
In what capacity is she serving? Is she a neuropsychologist? Is she an investigative journalist? Or is she an investigator?
She remains a neuropsychologist, agent of Zach Adams, who under my authority of the court's appointment, the statute says my job is to interview relevant witnesses. I would say Jason Autry was a pretty relevant witness to interview. I'd say Zach Adams was a pretty relevant witness to interview. That is the authority Dr. Spearco interviewed these people. But I didn't call her to do it because I thought she had a lot of free time. I called her because she's a neuropsychologist who could help tell me things that ordinary people couldn't. Much of her work has all expounded on that in the same way, in custody evaluations, she does forensic evaluations. She reviews school records. She's not a teacher. It's just what she does in forensic comprehensive parenting plan evaluations. She watches parents interact with kids. She talks to parents. She talks to collateral sources. All of this is, when I started the case, that's how I approached it, how I do other cases. It just happens to be mostly parenting plans. That's her work that she provided. The issue, the untangling of me, after the filing of this case, Dr. Spearco, Cindy Adams, and Dylan had communicated, I believe through Cindy, that Dr. Spearco that wanted to see Dylan. At the time, I consulted the rules of professional conduct, and you'll remember there's an order that I sought clarification. I believe General Nichols agreed in 2023. I think the order might not have found itself to the court until 2024. The rule about talking to represented clients is this. An attorney cannot speak to a represented client and knows to be represented in a matter where the substance of the representation is at issue. So I had a question. Jason Autry pled out and served his sentence. It was clear he no longer had an attorney under the appointment powers of the court.
I sought that, and I was also frankly trying to go see Terry Britt as well. I also did not know if the Bobo family, and I didn't know if the state agents, I didn't know how all that worked. That's why in the comments say you can go to the court and say, can I talk to these witnesses? The court and the general said, yes, you can. We put in there a provision that I would not talk to the Bobo family without communicating to the state first. So Dylan was still serving his sentence. And that's where I said, even though I have an order that allows me to talk to Dylan, I'm still uncomfortable talking with Dylan because I'm not sure I found this express order relieving Mr. Maddox of representing him. And Dr. Spearo didn't like that the ethics regarding speaking to represented people had to apply to her, because what you can't do directly, you can't do indirectly. That was why it was untangled. And the Adams brothers have fully agreed with that. There is nothing in the rule that says Dr. Spearo acting as a neuropsychological expert to Zach Adams, who helped me with her neuropsychological background and expertise in interviewing relevant witnesses and completing a thorough investigation, which I had to certify under Rule 28. Nothing says she can't make a podcast about it. In fact, and this gets to what a scaredy cat I am, when this issue came out last year, and boy, does this sound familiar? Out of concern for publicity, the state filed a motion to issue a subpoena to Dr. Spearo. And they said in chambers, the stated reason was to prevent the video going to 2020. But, and I've said this before, there's a remedy for the relief you seek, and it's a protective order. The court might remember the chambers meeting. The state, that was their request, was to bar dissemination of the Autry video. They called me immediately when we filed this, asking to seal Jason Autry's recanting video. I agreed. They asked to do it again. I agreed. Once it went to 2020, they never cared about it. They've attached things quite extensive. I remain, the issue of her podcasting is something the court has the authority under protective order. And in my response last April, after the allegation was, hey, all this is confidential, it can't be disseminated, I asked the court, is there a protective order? Am I under some order that I don't know about? The state has never sought to have that order heard. It's still pending. That's the irony of this. As it relates to publicity, the court can still do this. And my publicity is nil. There's a rule of professional conduct with me. Even though it's a bench trial, I'm not messing with it. I care nothing about publicity. I prefer this to be sealed entirely if the Tennessee Constitution allowed it. But the court has the ability, because Dr. Spearo is Zach's agent, to say, Mr. Adams, you are now governed by the following protective order, and it applies to your agents, which would include Dr. Spearo, which would mean there would be no publicity because she's Mr. Adams' agent. But until then, Your Honor, there's nothing in the law that says you cannot also be an expert and also have publicity. It happens all the time in cases where experts go on to court TV or other TV shows and offer their expert opinion on matters. And then they go to court and testify on matters exactly the same that they've just opined on other shows. It happens all the time. So If the court is concerned about the dual nature of this, there's no authority that it can't be. There is authority to enter a protective order if the court wishes, and it's been out there for a year. One final thing. Dr. Spearo, the idea is, okay, well, she's learned this, she's learned this, she's learned this. She's talked to this witness. None of that would be admissible unless she's qualified as an expert. She can't say, well, this is what I learned in my investigation, unless under Rule 701, she actually has firsthand knowledge of what took place. The only way you get around that is if you're a custodian of record or you're an expert. If you have a statement that somebody else made, first of all, Rule 17 doesn't apply in these proceedings. And second, it would be hearsay. And if anyone is losing by saying Dr. Spearo is not going to be a witness, it's the defense. So for all of these reasons, Your Honor, we request the relief we've asked for.
Thank you, Mr. Bates.
Briefly, Your Honor.
Yes, ma'am.
In a 5-month time period, I believe she and the defendant spoke 200 times. Again, numbers are not my strength, but in a 5-month period, Katie Spearo and the petitioner spoke over jail phone calls 200 times. Zach Adams probably is going to testify here. Who knows what he's going to say? She has information potentially about prior inconsistent statements that he might make to Your Honor that differ from what he's said before. Same is true with Dylan Adams. Last but not least, she got in to see Jason Autry under the guise of, and I want to make sure I get it right here, that she needed the recording device for transcribing purposes. You see, you can't get into the prison system by saying, I'm a neuropsychologist, but hey, I'm here to interview somebody because I need to send it to ABC 2020. I'm here doing a little bit of some broadcast news journalism. They're not going to let you in. You get in if you're a lawyer, and you get in through the lawyer if you're an expert going to do an evaluation. But that visit speaks volumes for the deceit and the shenanigans and the attempts to pull the wool over this court's eyes. We're not asking for a protective order. Again, we could not care less what is said outside the walls of this courtroom, who says it, and how many likes it gets. What the state is focused on is the walls of this courtroom and making sure that Your Honor has all of the facts and the truth to not only judge the evidence, but to judge the credibility of the people who testify.
Thank you, Ms. White. All right, counsel, I'm going to take this under advisement. I'll give you a ruling before we start the hearing. We have 3 motions in limine. Let's try to get those done before the lunch hour.
Yes, sir. The first is the Jason Autry video. It is the state's position that there is no exception under the rules of evidence that allow this to be played. And I'll just leave it at that. It is hearsay and inadmissible. The second is a motion to exclude any evidence not provided under Rule 16, a boilerplate motion that we always file. We believe Mr. Bates and Ms. Etu have provided us with everything that they have to date. And the last is relative to exclusion of any evidence or information about polygraph tests or voice stress tests. And those are, am I forgetting anything, Mr. Boyano? That's it.
Thank you, Ms. Wire. Mr. Bates?
Yes, Your Honor. As it relates to the voice test, polygraph, understand the statement of the law, understand why the state's asking for it, but that's the statement of the law.
issue on the discovery, we've provided everything we have at this moment. There is potential that something can be discovered that somebody's working on. I'll be honest with the court, I'm not sure it's going to be created or not. If it is, we'll address it then. If there's any motion along the way, almost 98% of our evidence is the state's evidence, or it was what Ms. Thompson had and the state's had it. So, as it relates to Jason Autry's video, and this was pled under Rule 804, that Jason Autry is a unavailable witness right now. I would love for him to be available. You'll remember the state said in a Zoom hearing, he's too dangerous to be transported from federal to state and to testify. He's just too dangerous of a person. You keep that in mind when you hear about Agent Ferguson and Joe Walker driving around the back roads with them, meeting with General Nichols, preparing for testimony. So either he wasn't that dangerous then, or he's become incredibly dangerous in the federal facility he is. Regardless, my co-counsel has admirably learned law that I didn't know existed regarding trying to get a federal inmate to come and testify. I believe the record speaks for itself, and I'd ask the court to incorporate our prior efforts for Mr. Autry to come and testify. The state asked, and the court granted, that Mr. Van Harmon be appointed counsel for him, and the court advised him to file his notice of intent, and Mr. Autry has done so. Under 804A1, unavailability of a witness means the declarant is exempted by prior ruling of the court on the grounds of privilege from testifying concerning the subject matter of the declarant's statements. Additionally, it was my understanding in the March hearing he was possibly going to be on Zoom, and there were circumstances indicating that he had been sick. Put an asterisk on that. 804A4 says is unable to be present or to testify at the hearing because of the declarant's death or then existing physical or mental illness or infirmity. 5 is absent from the hearing and the proponent of a statement has been unable to procure the declarant's attendance by process. From all of those reasons, Your Honor, we say first the threshold is that he is unavailable. Then it goes to a statement 3, which is a statement which was at the time of its making so far contrary to the declarant's pecuniary or propriety interest, or so far tended to subject the declarant to civil or criminal liability, or to render invalid a claim by the declarant against another, that a reasonable person in the declarant's position would not have made the statement unless believing it to be true. In the record, and let me just say, the state should know that Mr. Autry's attorney did not withdraw because of any impropriety of Dr. Spearo at my request meeting with him under my statutory obligation to interview relevant witnesses. I would love for us to have a hearing on that issue. Love it. Unfortunately, I believe the federal government has advised Attorney Boswell not to discuss it. But Mr. Autry's pleadings in federal court pending his sentencing hearing, where he was trying to get the benefit of his cooperation in obtaining a conviction. he has provided a recanting that is wholly inconsistent with the benefit that he was seeking from this at the sentencing hearing. It also subjects him, his testimony, that in 2017 I committed perjury, subjects him to prosecution for what took place in 2017. And for those reasons, Your Honor, it is a statement against interest. There are other Your Honor, I would also argue there was a time when this case was consolidated, and then it became unconsolidated.
This post-conviction matter.
Not the post-conviction matter, the underlying trial.
Okay.
And, Your Honor, I'm frankly not sure how 803.1.2 regarding a party opponent affects it. These were admittedly co-defendants. I'm not sure it fits under that, 803.1.2. It certainly fits under Rule 804. But for those reasons, Your Honor, the video itself, he's unavailable. He's unavailable multiple ways, although I would welcome the court not foreclosing on Mr. Autry coming into court again in person and testifying. I'd certainly welcome that. The court indicated it would not do Zoom, and so right now we've tried everything we can. The state says he's too dangerous to transport. The court's indicated it's not going to do Zoom. We're at the mercy, and all we have are these rules that allow if it's unavailable, it's unavailable. If you have a recording, which we do, if it's a statement against interest, which it is, it's admissible. Thank you.
Swear.
The state wasn't about to sign a writ transporting Jason Autry to testify in this court and continue this deceit. Let me remind the court again that the state has information. We have heard it out of his own mouth. The reason he sat down with Katie Spearo for this tete-a-tete was revenge. This isn't a recantation. It couldn't be further from the truth. This is a publicity stunt. They're effing with me in federal court. I'm going to F with them in state court. Katie Spearo knew when she started the interview he was doped up on something. This tete-a-tete has no scintilla of reliability. And for anything to fall under the exception that Mr. Bates is advocating, there has to be some corroboration to it. It has to be something that the court can find some ounce of reliability to. This is nothing more than two people sitting down and having a talk. It is not a recantation. It doesn't set him up for anything. It doesn't set him up for perjury. The state of Tennessee can't indict him for perjury for a conversation he had with Katie Spearo. I have no idea what statute that would fall under. He would have to come into court under oath and say what he said on that video to Your Honor for that to happen. But he is protected by the Fifth Amendment, and he has decided to exercise those rights. This statement cannot come in under any exception to the hearsay rule for the simple fact that how does the state of Tennessee cross-examine the person who uttered the words? They're not here. So how does the court get a full picture of the motive behind it, of the state of mind of the speaker, of setting the stage of the true scenario? It can't happen. And that's why the rules of evidence protect it, and that's why the case law, we've got a copy here of State v. Dotson, a Supreme Court decision from 2008, talk about accomplice, whatever you want to call them, co-defendant, accomplice, testimony has to be corroborated. It cannot be self-serving. And this was wholly self-serving. This was Jason Autry's continuation of the fame that he got. The one decent thing he's done in his life. Take the stand here and tell that jury what happened that day. This is not a recantation. It doesn't help get the court any closer to the truth, and that's why our rules of evidence protect it and say that it's not admissible and it has no place in this hearing.
Thank you, Ms. Wire.
You want a copy of this?
Dodson? Yes. Mr. Bates got a copy?
Thank you.
Our counsel, any other matters that we need to address before I make rulings on these motions and potentially start the hearing after lunch? Any other motions that we've missed?
Not from the state, Your Honor.
Mr. Bates? C2?
No, Your Honor.
Nothing from the state either. All right. The court's going to take these matters under advisement. It will take me some time